group whose rights must be considered, deliberated upon, and noticed, that of convicts who have been granted death penalty sentences. The constitutionality of capital punishment was upheld by the Supreme Court in Bachchan Singh versus State of Punjab, applying at the same time the rarest of rare cases standards, which is that the death penalty shall be imposed only in rarest of rare cases. Applying the rarest of rare cases standard, the court had also given broad guidelines or indicators for sentencing, which account for aggravating and mitigating factors, while cautioning that this assessment must account for the dignity of human life. These principles have further been evolved in cases where the court has broadly categorized 5 heads of sentencing. Through the years, however, there has been concern over non-uniform, inconsistent sentencing, which has permeated to the district courts and the high courts. Recently, the Supreme Court has recognized the need of ensuring that mitigating circumstances are considered at the trial stage itself, such that proper evaluation of the progress of the accused and their mental state, family background, and education can be conducted to arrive at an appropriate sentence. The need for a uniform pattern of sentencing, while accounting for various psychological, social, and biological factors, is necessary to ensure that criminal law does not appear in its application to be inconsistent and a game of chance. A very crucial procedural intervention by the Supreme Court is now to ensure that every review petition in a death penalty case is heard in open court by a bench of at least 3 judges. Reviews in the Indian Supreme Court are disposed of by circulation, by the judges discussing the case in chambers. Our court ruled that a review in a death penalty case has to be heard in open court. And some of the results which we have seen as a consequence have been startling, if only satisfying for the judge delivering the verdict. For instance, I had a case where an accused had been sentenced to death. When the review came up and we asked the counsel for the accused as to whether they were pressing for commuting the sentence of death to a sentence of imprisonment for life, counsel said, well, I understand that I'm in review, but if you give me the rest of the afternoon, I'll not only persuade you to the belief that this is a case for commuting the sentence of death to life imprisonment, but I'll persuade you to hold that this is a case for a clean acquittal. And we acquitted the accused. So some of these procedural interventions, I must also emphasize the continuing engagement of groups of citizens with the Indian Supreme Court. We have the academia. We have very significant involvement of the academia with the Supreme Court. The academia has been persuading the Supreme Court to ensure that a psychological evaluation of a death row convict is carried out so as to enable the court to assess as to whether the mental health of the convict is such that it would be justified, even if you uphold the death penalty, to execute the death penalty. Or would it be contrary to the principles underlying Article 21, which protects life and personal liberty?